Hello, you are welcome back to this week's podcast, and I am, I suppose, maybe a little bit proud, a little bit of a fangirl, if that's the right language, maybe it's not, of this incredible individual who's on the podcast this week. And this week I'm talking to none other than Gareth Noble, solicitor and partner in KOD Lyons Solicitors. I know many of our listeners will be aware of Gareth and the incredible, I would almost call it human rights approach that he has to supporting families just like mine and children just like my own and parents just like me all across of Ireland. And I know that on today's podcast there'll be, I suppose, a various amount of topics that we're going to discuss, and in particular we'll be focusing on educational rights, if you're accessing services or maybe not, unfortunately, being able to access service. So Gareth is going to talk on a range of topics today, and I'm going to hand over now to the main man himself to maybe introduce himself a little bit more, and I'm going to be silent now so you hear from the most important speaker on this podcast this week.
Wow, there's no pressure after that introduction, Amanda. And thank you so much for the invite to join you on a Saturday night. I think we're recording it on a Saturday night. A cold and dark winter night. So it is great, and I'm really thrilled to have the invite. So thank you so much. For those of you who don't know me, my name is Gareth Noble. I am originally from the lovely Lakeland county of Fermanagh. But I've been in Dublin now probably a lot longer than I ever was in Fermanagh. And I qualified as a solicitor in 2006. I joined my current firm when I was already in college, so I feel like I've served a life sentence already. Started off doing criminal law, went into the whole area of juvenile justice and young people. And then I really sort of got really interested in children who kind of came into conflict with the law and trying to understand the reasons why that may be. And then I got involved in child protection law, and I do a lot of that around the country. And then that has led me into the areas of education, carers, and disability law. And each of those different facets are really brilliant in their own way. And yeah, that's where I am today.
And can I ask you, Gareth, do you feel, just even, I suppose I'm speaking more, I suppose, as a parent tonight, but do you feel like the work that you do, because I know you're a parent yourself, do you feel like you take home some of that kind of overwhelm? Because there's some very emotional, I suppose they're all emotional because it's family. Do you ever feel like you take home some of that kind of heartbreak? Because you'd love to, you're doing your absolute best, but sometimes, it's an uphill battle, just even trying to get somebody to listen. And that would be my own experience just as a mom day to day, just trying to navigate the world for my kids.
Okay, so from a legal perspective, when I get the query in, I go into battle mode, okay? And I get into the zone where I'm just really just trying my best to help people out, and we need to navigate this challenge and all those kind of things. But here's the bit that gets me, okay, in here. It's when it's all over and you get a good result and you get, say, a thank you letter from a child, or you get a thank you poem, or like the other day we had sorted out a school transport thing and I got this card in from a child, and it was a picture of the child with a big happy face looking out at the bus waving. And I have to say, it's those kind of things that get you. So it's not the emotional side of the legal work that gets me. It's the human side of the reaction, particularly afterwards, that can sometimes be emotional.
Yeah, because you see, it's not paperwork to you, and it's not paperwork to the family. It's lives on the line, and it's livelihoods on the line in the sense of, if this child doesn't have the opportunity to access school or get the transport to school, what will their life look like? So yeah, I just feel as a parent that, and I know I speak for many of our listeners, we're so thankful for incredible individuals like you that do so much for our community. So do you want to speak maybe a little bit about, say, I don't want to say hot topics because every topic is so important, but say topics that are coming into you, say, more frequently, maybe a trend that you've noticed, or maybe it's just, excuse me, I can never say that word. Debated. Have I said that wrong? I feel like my Mayo accent is at play here. But is there a particular trend, or what are you finding, I suppose, coming into day to day in regards to support?
Yeah, I mean, look, every day is a different day, and I often say to people, okay, people come to me to look for advice and guidance, but I always find that I learn so much from different cases and different experiences, and there's still things that come in every day that are new and are fresh. And actually, a lot of the things are seasonal as well. So at this time of year, for example, school enrollments for next year are a big issue, particularly, sort of starting off in primary school, transition to secondary school. So that's obviously a big issue. We're seeing a lot, I guess, of, children being perhaps in inappropriate educational settings without the right supports. That's a through the year thing. We're seeing, obviously, the overuse of school disciplinary codes as a response to children who feel overwhelmed in that environment without this space. That's an ongoing thing. School transport is obviously, I mean, there are kids today who are approved for school transport in September who still haven't got their school transport sorted out, as in the middle of, or what are we, the third week in March now, okay? We have reduced school timetables being a big topic of conversation as well. And assessment of needs and access to services are year round and looks like it never ends, in fact, in terms of all of that aspect of stuff. So sometimes you get certain points of the year in which there are certain topics that come in, but perhaps depressingly, we're seeing issues that you think should be resolved quicker actually taking an extraordinary amount of time to resolve. And that can be days, weeks, months, and sometimes years.
And even just listening to you there, I was thinking about one of my sons when they were making the move from primary to secondary, and I feel a way, maybe I don't want to say was I living like I suppose behind the veil of what was real. Like I understood fully what's going on because, you know, I have so many families that, you know, I talk to every day that are experiencing difficulties with schools, but it had never landed on my own doorstep until I had to try and find a place for my eldest son to go to school. And the first thing that I noticed was that, for secondary school, was that there wasn't actually, whereas for my eldest daughter, she could pick where she wanted to go. And there was nobody saying, well, no, actually, you can't. Whereas for my eldest son, now we were lucky that we did get him a great school place, but we were limited to basically that was the only choice. And we were lucky that it worked out for him. But again, do you find for families that if they've already done actually, this is probably an interesting question. Do you find you've supported families that go into primary, that you've battled for them, and now they come back around when it comes to secondary, that now you're meeting the same family again, that they actually have to battle again with you, or not with you, but like you want by their side?
There's two interesting points about that. Yes, I am now at a point where I've battled to get a child into a primary school, that I'm now battling for the same child for a successful transition to secondary, the cyclical thing. And I want to talk a little bit about that in a second. The other thing that I'm finding is, and I've had this a number of times even this week, you helped me 4 years ago with my older child, and now I'm going through the same set of circumstances with my next child or the third child down. So those are depressingly familiar. But can I say one thing just about the transition to secondary? If we just take autism classes as an example, okay? If the Department of Education and the National Council for Special Education were fit for purpose, if they were, then surely they would have the data that would see coming down the tracks, we're going to need the same number of school places available at secondary school than we have here at primary level, because we know the number of children who are in autism classes in primary schools. We know the numbers that will be transitioning to secondary school at a particular period of time. And it sort of beggars belief sometimes to see a situation in which these mistakes are repeated again and again. And we don't really ever seem to learn the lesson. I mean, I'm sick and tired of listening to government ministers saying, oh, well, we got it terribly wrong for this year, but next year we'll have our house in order. I've heard that for the last 5, 6, 7 years. Successive ministers over a department that really doesn't have a clue in terms of the numbers, the need, and meeting that need. And the other thing I'd say from a legal perspective, and actually this isn't me saying this, these are lawyers who are acting for the state tell me privately this. Any progress, and there is some progress being made in terms of opening new autism classes, in terms of, you know, pushing on the number of SNAs, etc., that has come about not because of some great visionary within the Department of Education, and certainly no great visionary within the NCSE, but has come really about through parental pressure and parental advocacy and the advocacy groups and organisations that work in this area. That's where the real pressure has come from in order to bring the Department of Education back onto the pitch of play. I mean, it seems to me to have been an extraordinary situation whereby the Department of Education had no power or influence or control as to whether a school could or should open an autism class. And of course, it's only in the last couple of years that they brought that power into being in certain circumstances. So it's really the advances we see in the educational policy area are come not out of great empathy or understanding of the situation of the parents and families that I act for, but because of those parents and families doing what they're doing. People often say to me, you know, you have the most interesting, challenging, wonderful, fulfilling job, and all of those things are true. But my job is completely unnecessary if the Department of Education and the Department of Health and the HSE and others did their job. And I would be the happiest redundant person in the land if they could simply get these things right. Because one of the great, I guess, and surprising things for many parents is that in the area of education in particular, children and families have, and I say this all of the time, many more rights than they think they have, and certainly many more rights than they're led to believe that they have. And it's extraordinary to me that, in fact, it takes a legal challenge to something like a school placement to bring about a situation where that child has a basic fundamental constitutional right honoured. And it beggars belief that someone would need to go to someone like me for something so fundamental. And I mean, we have children who are promised the sun, the moon, the earth, and the stars. And then as soon as the light or the camera goes off or the microphone heads off, and we've seen countless examples of this, then they're forgotten about. And so the challenge for all of us is to keep the issues on the agenda, get them onto the agenda first of all, and keep them on the agenda. One of the really interesting features of the last general election campaign is it was the first election campaign ever that I can think of in my lifetime where disability rights and educational rights and carers' rights were actually being discussed during the election campaign. I thought that was a really good breakthrough. Now, the challenge is, now that the ballots were counted, is to make sure that people honour those commitments and really do bring forward what people are telling them. And I mean TDs and senators every day of the week in their constituency offices, in their email inboxes, in their stories that they bring to the gates of Dáil Éireann, etc., etc. So as challenging as it is, and as foolish as some of the things of the decision makers that are made, there's actually some really, really good, positive, constructive things happening. We have a very good media in this area that are really covering these things. I include podcasters like yourself and the whole form of new media that is really taken this by the throat and really has really harnessed, I think, public awareness and public understanding in a way that was never there previously. We actually have, and this is a secret, but we have actually a very wonderful judiciary when it comes to these types of issues and rights, because they're not there to make law, and they always make this very clear to legal teams. They're not there to create laws, but they're there to enforce laws. But, when a child who doesn't have a school placement goes before a High Court judge, I can't think of any cases where that child has failed to secure a school place, but it is completely inappropriate that they ever have to take that step in the first place.
I suppose bringing it back to, just some of the topics that we were going to talk about today, do you think, or would you be happy to, for example, give an example of, say, challenges that you're finding families are facing specifically with accessing school today? And if you had any advice for any listeners that may or may not, would say if there's some particular cases that might pop up often for you, if there's any listeners, say a family that you would say may have a similar experience, if they're saying, well, what can I actually do if I cannot find a school place for my child? What are the mechanisms I can access, or what legally can be done if I'm being told there is no school place, say, for my child in this particular area?
Okay, well, first of all, the obligation is on parents to make the application for enrolments, okay? So the first piece of advice always is, some parents will be told, well, don't apply for that school because you won't get in, and then they don't apply. And as I say to parents often, the only guarantee of never getting into a school is if you don't apply for it. I mean, you're guaranteed never to get into that school, okay? So the second thing, obviously, is to kind of understand and know their enrolment criteria. And if, for example, it's an autism class, I'm using that as an example, but if you have an autism class, you have to have a diagnosis of autism, right? And the other aspect of matters is that quite often, schools, even particularly in special schools, for example, they require certain reports to say certain things. And so the other thing that I would suggest to parents is that whilst you need to understand and know the enrolment criteria, so should those who are helping you to secure and to access that school place also know what the criteria for that enrolment is.
But say if you're a parent and you're saying, like, maybe somebody's told you that there is no school place, locally, you'll have to apply somewhere else, X, Y, and Z. What would be your advice to a parent today that is concerned because she's hearing from local people, there's no school places locally, you'll have to, go further. We'll say Dublin, a really densely populated area where, you could be living in one area where your child might have to go not even across the city, literally almost across the county. What would be your recommendation for a family that's thinking, maybe for this year, they're probably in the midst of it, but say for next year, if they're saying, well, I would say if it was Max back in time, if I was now living in Dublin and Max is for primary next year, what should I be thinking about right now doing, I suppose?
Okay, so the first thing I guess to point out is that from a legal perspective, the obligation is on the parents to make the applications for the enrolments, okay? And we are in a situation, obviously, where some parents are told, well, don't apply to that school because you actually won't get into that school because it'll be oversubscribed, okay? The one guarantee, of course, of not getting into a school is if you don't apply for it. The same way as you'll never get domiciliary care allowance if you don't apply for it, and you'll never get an assessment of need if you don't apply for it. Okay, so that's the first thing. The second thing is obviously to kind of understand the criteria and the enrollment criteria for it. And then obviously, schools have their enrollment criteria, and the biggest obvious reason why somebody would be turned down for an enrollment in a school is oversubscription. Okay, and that's where the state comes in, because the state obligation is to ensure that every child has their constitutional right to suitable educational provision vindicated. And so what I would say to parents is you make your applications to the various schools. You hold on to all of your paperwork, particularly the ones where they say that they're oversubscribed. You then contact your SENO, the local special educational needs officer, with your paperwork. And on behalf of the state, you are asking them to identify a suitable and appropriate school to meet your child's needs in accordance with what is required. And you're forwarding them copies of all of the letters and all of the schools that don't have it. The other thing from a legal perspective is that when we then correspond with the Department of Education, we always identify a reasonable timeline within which parents should be provided with that information. And it's when that reasonable timeline is not complied with that from a legal perspective, then you may need to go further. Obviously, in my experience, and it is always my advice, that you do that work first, because certainly giving the Department of Education and the National Council for Special Education the reasonable opportunity to sort this out and resolve it makes it a stronger case than if they don't. But I mean, I could probably paper your living room and my living room with lots of letters from the Department of Education that tell us they will revert back to us with a substantive response. And the only substantive response you ever get is when legal proceedings are instituted. But having said that, a lot of people think I'm going to end up in court over this. And yet 90% of all education cases that I deal with never see a court. And that's obviously a positive thing because is resolved. It's not resolved unless, it's not resolved, because suddenly, as I say, there's some great visionary who takes immediate interest in a case. The immediate interest for that case comes because there is a case. One of the other really interesting features about education law that I've seen is that, for example, it is almost impossible to get 1 hour of speech and language therapy from the HSC outside of your functional area. Okay, impossible to get it in the next town. And yet we are sending children off 45, 90-kilometre round trips per day outside of their school communities because of that lack of planning. And we see millions of euro in busing children out of their local communities to go to school. Even for, and for many children, preparing for school in the morning, getting up, getting there, they're exhausted by the time they arrive. And because you've placed that additional pressure of the journey to school. And it always seems to me to be a really bizarre thing that we have this complete contradiction that I can't get an OT locally, but I can certainly have to go and spend 6-7 hours in a classroom per day, and then perhaps spend with the traffic, an hour or 2 hours at least to get home. I mean, that's not good planning, and it is, it's just really unfair on those pupils, but unfortunately for many, an unnecessary evil because we don't have a legal right to be educated in our local community. The constitutional provision doesn't extend to that. The constitutional obligation is on the state to provide for an education. That education has to be suitable, has to be appropriate, and has to be adequate. But For many children, they find it not an impossibility, but an additional burden and an additional struggle. And it always seems to me to be, again, another example of really poor planning. And as I said to you at the start of our podcast, I'm still dealing with children and families whose school transport still hasn't been sorted out. And here we are, in the second half of the school year.
Then Gareth, then I would regularly through my own social media little puddings be chatting to parents all the time, and they would often say, they'd ask me, and being honest, I'd always direct them to your brilliant self. I'd say the best person to speak to would be a solicitor. I'd say it's not my area, but say if you're a parent and say there was a school local. No, I'd say no. Say there was a school local to you, but you felt for whatever reason it wasn't suitable for your child, and then maybe there was a school suitable, say. So where I live now in the west of Ireland, I'm actually between 3 different small towns. So I'm in close proximity to all three, very rural. So say if I wanted to have one of my sons go to school A, but school A we'll say not the closest to the house in kilometres, but they're all very close, but not the closest. And then say if a CNO comes in and says, oh no, that's closer, that's the one you go to. Even though I know for a lot of my sons would have significant needs, I would know personally this would not be the right place for them. They wouldn't thrive there. They would struggle, X, Y, and Z. Can a CNO say, well, that school is closer, so therefore you absolutely must go there, even though and the reports say may not be suitable? So what can families do or can they do anything, I suppose, in that regard?
The one thing that I'll say is that from an educational perspective, parental choice isn't high up the agenda. Okay, so that's the first thing to say. So it's not really that a parent can insist on one school over another if they are similar in nature. Let's use that term. Okay. And I used to find this quite a lot, not so much recently, because there have been some legal challenges in relation to this, and I think the penny is slowly beginning to drop. But it used to be the case, for example, that parents weren't able to avail of the school transport grant because they weren't attending the nearest school available to them. Now, of course, what the actual circular actually says is that the nearest school suitable to meet that child's needs, which is different to the nearest school. And so what we were really getting into at that particular point was pointing out and needing perhaps information as to why the school further on, as you've said, is more suitable and appropriate. So it's not really framed from a legal perspective in terms of parental choice, but it's in terms of whether or not the nearest school is inadequate to meet the child's needs. Okay, it's not suitably resourced to meet the child's needs. So I, for example, might have a parent where the reports place great emphasis on the need for small classroom environments rather than noisy, sensory overloaded environments with, 35 pupils in the classroom. Okay. And so what we have therefore is, if you have that, but you have a school that is further on down the road that has 20 kids in the class rather than 35, we can advance certain arguments, because we have to build a system around meeting the child's needs rather than the child having to build themselves around meeting the system's needs. And when you think about it, the constitutional provision in relation to a child's education is a child-centred right. It's a right that is in them or provided to them as an individual. And so my legal argument always is you have to look at the needs of that child in order to have that right vindicated. And so we're seeing this, for example, say, for example, in the assessment of need process, there is a provision where you can get an educational assessment provided, okay? And the NCSE are nominated by the HSE to provide an educational assessment, and the NCSE in turn then have to nominate somebody to do it. And in recent times, the NCSE have taken it upon themselves only to nominate the school teacher and the school principal to do those educational assessments, okay? And there is, in certain circumstances, nothing wrong with a school principal or school teacher assisting in those assessments. But there are many teachers and principals who say, if you look at the profile of this particular child, then we need more professional input, whether it's from an educational psychologist or somebody else, in order to do that particular type of an assessment. Because if you're looking at it from the needs of the child, has to be the start, middle, and ending point. And you know what? It's not the parents who come to me to say, saying or claiming or demanding that they have the legal equivalent of Disney World at the doorstep. They're not advancing even, the best possible provision, but they do want the adequate provision. And, parents are, for the most part, incredibly sensitive and sensible to what their child can do and cannot do, can achieve, and need the tools to achieve. And I think sometimes there is a little bit of official dismissing of what the real expert in a child's life is, their mum or their dad or both, and not a lot of creative thinking in terms of how to meet that child's educational experience. For example, and it's a totally different type of scenario, of course, but I was always struck in my early days working in the children's criminal courts, just how many children had left school early. And the reason that they had left school early was obviously for a multitude of potential reasons. Their parents may not have been able to get them there for whatever reason. There was a lot of maybe school avoidance or school refusal, suspensions, expulsions, traumatic events in that child's young life, etc., etc. So there's a whole lot of, okay. But it always struck me that there was never a real analysis of an educational experience for a child and why that child has come to be outside of the educational system. And there are no studies done. There's no exit interview for a child or their family in the same way as we have in employment situations. No analysis of, what is it that we as a society can do better for you in your next experience. And the other thing to say in relation to school enrollments and school placements, generally speaking, is that sometimes that school is not a right match for that pupil. And parents find that they're doing their level best to engage with the school, to work things out, to resolve matters. And sometimes, for everybody concerned, a fresh start is often the best way, because there comes a point sometimes when it is impossible to restore trust and to put things back together again. And the other thing is, and you'll have known this, and we all know this, there are examples of brilliant school leadership and brilliant experiences for many children in our schools, really good. And there are many, many schools that go the extra mile. And so it frustrates me considerably when we see examples of schools falling far short of what is required, because the good examples demonstrate that everything is possible. And I often get parents who come to me, for example, who, and ask about the individual the IEPs, the individual education plans. I think they're called something else at this stage. But, people say to me about my IEP, I've dealt with, and sometimes you say to schools, where is the IEP? Now, there is no legally enforceable right to an IEP because that part of the Epson Act was never, in fact, commenced. But I would see examples of schools that have amazing IEPs, color-coded, laminated, up on the wall for the inspectors to see, but they're never implemented. They're never actually honoured. They're never actually addressed. And yet I might see a school, and I'm not taking the West of Ireland as an example, but I can think of one school recently where, the IEP is effectively written on the back of a brown envelope. But because they totally get it and they totally understand that whole real concept of inclusion and diversity and understanding and, looking at this through the child's lens, etc., etc., and they wouldn't even think of writing it down because it's in here and it's in here. Those are, to me, the best examples of good practice. You don't need to write it down if you have it instinctively and culturally with the right support from the Department of Education in schools. The final thing that I'd say about school places and, and sometimes, difficult relationships between schools and parents. In many respects, the more I do this job, the more I see that, in fact, the way our whole educational policy framework is set up, it is often set up in a way that pits parents against principal by the Department of Education. Now, I'll give you one example of that. Every year, schools have to apply for SNA support for the following year. And it causes huge insecurity within schools, huge insecurity within our wonderful SNA community. And you have this cycle of insecurity and not knowing every single year. And I'm often struck by the fact that obviously a block of support is provided to a particular school based on the general profile of the school. But it is then down to the principal to allocate that SNA block of support among the pupils that they feel require it most. And I'm often struck by
how lonely a task in some respects that can be for a really committed school principal who knows that in fact the department have fallen far short of what is required, and yet they are then left in a situation where they are having to tell certain parents that they are not getting the support that the school principal and the parent feel ought to happen. And it is often those legal cases that end up being the strongest, where you have that alliance between the school and the parent, and where the school, as they often say, these children have constitutional rights. You've delegated the day-to-day functioning to us as school principals, but we're not actually able to do it with the resources you've given us. That's a very powerful legal advance, because if you have principal and parent actually working together to increase the resources for the school and also for the pupil, well, then that's a very powerful alliance in terms of school being able to say to the department, well, actually, the resources you've provided us with do not enable us to enable the child to access the curriculum in a way that is appropriate and adequate. And of course, those are the key legal concepts involved. And also, too, I'm often struck by the fact that whilst in theory there is the ability for schools to engage in what is called an exceptional review, so they look for an exceptional review of S&A provision and so on, many schools are actually fearful of undergoing an exceptional review because A, they're worried that they will in fact lose the current provision that they've been given, or B, what the NCSE do routinely in many instances is they actually throw the school principal under the bus and somehow make out the case that somehow they're misusing or abusing the allocation of resources that they've already been given. So there are a lot of very soft barriers for schools and parents to be able to access what they need. But it all comes back to this idea of adequacy and appropriateness. And it all comes back to the basic point that we started this conversation with, and that was that from an educational perspective, children in Ireland, thankfully, have very, very strong legal rights. And, healthcare and housing provision are all very much subject to resources, and there's a lot more questions around expenditure and et cetera, et cetera. But you see, you cannot breach a constitutional right by saying we're not going to give money to that. Because you can't breach someone's constitutional rights by saying, well, we won't pay for that. And that effectively is what a lot of the issues are around resourcing schools and resourcing supports for schools and opening new classes and so on. So in many ways, it's a difficult challenge for many families, but in many respects also it is those families standing up and not just asking but demanding that their child's rights are properly provided for. They make, in many, many, many instances, I'd say the vast bulk, they mightn't get everything that they set out to achieve, but they certainly do advance it when they understand what their legal rights are. And certainly those families, and it's a sad reality of life, those families who do understand what their rights are in a much better place to navigate what is a difficult system than those families who are, for whatever reason, unable or don't understand, in fact, what their legal rights are.
So I suppose, Gareth, on the back of kind of what is best practice occurring in schools where you see where the school and the family are the team, when things don't go well then with school and family, are there particular scenarios that you see emerging, and is there any advice, say, on the back of those particular, say, examples that you might have that, say, families listening or parent listening that might take, say, some, I suppose, advice from what you're saying in the context of, say, if I give you an example, if, say, family are saying child needs X support in school, but school are saying child doesn't need that support, or if family are saying child is having difficulty in school by the nature of the fact they're autistic, that what you're seeing as a challenge is the child is actually, it's the autisticness of it all, if that makes sense. Maybe school sees it, maybe, the language that I don't really like, for example, challenging behaviour. Is there advice there for family, or would they be scenarios that might come across your desk day to day, would say?
Yeah, they do. They're depressingly familiar. And I guess it does come back, first of all, to the type of leadership that is shown by schools in the first place. But when you're in a scenario where there is that blockage and where there is that really refusal to proactively engage, there are obviously a couple of things. First of all, parents always try and seek to resolve it one-to-one. But if that fails, then obviously every school has a school complaints procedure that they have to really exhaust and go through. And this is a challenge for advocacy organisations as much as legally, our school complaint system is completely broken. You cannot have a scenario, and I mean this respectfully, where you would have a complaint about a school principal. You go to your board of management, and the school principal is the secretary to the board of management. I mean, that is, by any accounts, massive glaring conflict of interest. I also feel sorry in many instances for boards of management who are not trained, who are not supported, and who don't have the resources to deal with complaints effectively and appropriately. So we have to come up, and the Department of Education really do have to come up with an alternative mechanism to bring about the speedy resolution of complaints. The other thing that I see in relation to school complaints is that it takes an extraordinary level of time in order to address it and to go through the various stages, even if you're going through it meticulously and so on, because inevitably, the longer, we see this in every nature and every facet of life, the longer the conflict goes on without being resolved, the harder it is to resolve that conflict. And so if this cannot be resolved in a very short space of time, it lingers from whatever perspective you look at. And therefore, we have to have a situation where we bring about quick, expeditious resolutions. The other thing I'd say to a parent who would be at odds perhaps with the approach of a particular school is to make it very clear that not only to set out what your difficulty and your challenge is, number one, but secondly, particularly for boards of management, also to set out particularly what you see as the solution to the problem. So if you always come to the table with the solution to the problem as well as the problem, I often find that those are the ones that can get resolved pretty quickly, because schools immediately get very defensive and they think to themselves, oh, what's going on here and what's all of this about? Which is why, for example, in many school complaints, I don't become involved until quite later on down the line. I'm sort of behind the curtain a little bit in assisting the parent progress and process the complaint and to give them the advice in relation to it. But quite often schools naturally, we see it in the medical field as well, where the guard comes up because where is this all going? ? And I think parents who are very genuine in their attempt to try and resolve matters and get on with it, parents are too busy to be involved in ongoing disputes with schools. But you get in there, you diagnose the problem, but you also come with the solution. And those are the ones that quite often get resolved a little bit more quickly. The other thing I guess to bear in mind, and I'm mindful of a particular case I was involved in not that many years ago at this stage, but where a child was expelled from a special school. And we won the Section 29 in relation to that case, and then the school successfully judicially reviewed the Department of Education in respect to that. And one of the really interesting things that came out of that case was that in terms of solutions that parents and ideas that parents may have, there is a great emphasis in looking at the legality of the decision made in terms of then what suggestions were there, either from the parent or indeed professionals working with the child, to avoid, for example, a school suspension or a school expulsion. And so the focus then would very much turn to, well, if that was a reasonable solution and that wasn't tried, does that go to the lawfulness then of the decision to expel? And what the court found in that particular case was that the solutions that were suggested after the expulsion actually was done rather than beforehand. And I feel that sometimes expulsions are in real difficulty from a school perspective if solutions had been suggested prior to that and not implemented. I mean, I find one of the funniest things is, the parents often, through their own resources, would say to a school, I will make available to you, the behavioural therapist or the speech and language therapist or the OT or the psychologist that we're working with through the CDNT or privately or a primary care. And those professionals, those frontline SLTs, OTs, SLTs, are absolutely making themselves available to go to the schools to provide them with the support necessary. And some schools, when they do get that professional input, it creates such a different dynamic and a new vibe and everything goes on. And then you have schools and say, can't let that therapist come in because, are they Garda vetted? Or are there GDPR issues about other children? I mean, schools would not function if we took the approach that everybody who went into a school could potentially GDPR violation. I mean, where would we be without sports coaches in schools, or music teachers, or parents coming in to volunteer about certain things? Or, I mean, the list is endless. The idea that a qualified KORU speech and language therapist or a qualified KORU registered occupational therapist is in some way, banned from school properties on GDPR grounds is again one of these bureaucratic and legal nonsenses. And there's certainly no Department of Educational guideline or guidance or circular that doesn't envisage that type of support being made available. Hillary Clinton once wrote a book called It Takes a Village to Raise a Child. And I think we need to approach education, particularly in the area of for children with additional needs, on the basis that it takes a village to educate this child. And we need to harness all of the potentials, the parental input, teachers' input, all of these things. And we need to say, instead of no, how can we do this? I mean, I just love school principals when you're talking to them and they say, this and this has been asked of me. How do I do this? How do we do this? I mean, that is such a wonderful phrase to hear, because it's immediately constructive and positive, rather than the sort of computer says no mentality that happens. And I'm not singling out schools for this. It happens right across our public bodies. How do we do this rather than no? And I think that if we had that as the starting point.
I'll give you an example of something that was mentioned to me the other day. I had let the parent know that I'd be chatting to yourself, so I thought, it'd be relevant as well, because it's something that happened to myself as well. For one of the boys, when, for example, one of my sons, I won't mention which one, when they had gone through the assessment of need, what they didn't get immediately, this only came up because I was chatting to another parent about it, that they didn't actually get their service statement for many years later. And then when they did get their service statement, they might as well have not got their service statement, because there was no actual timeline for anything. And I was just chatting to this parent again. We would have kind of started out together many years ago when my eldest son Connor was born. So she would have, I suppose, multiple children that would be autistic like I would myself. But she was mentioning that in relation to one of her children, that when they got the assessment of need a number of years ago, they didn't actually get the service statement until many years later. And then I said, actually, that actually happened to me as well. And it only, and I won't give a time frame, but in the last 12 months did we finally get the service statement, because it's actually somewhere in this office where I'm chatting to you. I'm thinking about it's in a brown envelope. But I thought it was interesting, because when I read it, it was essentially saying, there is no timeline for any type of therapies. And they haven't actually, now very recently, one of the boys actually has been able to access some supports, but none of the boys across the board has had any supports. So this family in a different part of the country completely, but very similar. So in relation to the assessment of need, that's a very specific question now. I suppose that, it doesn't apply to myself or to that mom anymore because she has it. But if you're a family and you've got the assessment of need, but for some reason you haven't been provided with the service statement, if a parent wasn't aware, how important is that service statement? And if they haven't got it, what should they be doing about it?
So this is very strong legally, from a legal perspective. We all know that under the Disability Act, the HSE must commence your assessment of need within 3 months, and it must complete it no later than 3 months from its commencement. We know also that it is the exception rather than the norm that they do that. And if they don't comply with that obligation, then there is legal remedies open to you through the complaints procedure, and then enforcement of that complaint through the circuit court. And the one thing I'd say again, when you're going through the courts, there hasn't been a single case we've lost in the circuit court, not one, in terms of the delay to a completed assessment of needs. That's not because I'm brilliant. It's because the law is crystal clear. The lack of resources is not a defence to the commencement and completion of an assessment of need within that time frame permitted by law. Now, your specific question is, I get my assessment of need at whatever point in time, what happens next? Well, if you have a completed assessment of need and your child meets the definition of disability under the Disability Act as part of that assessment of need, within 1 month, you are legally obliged to receive a service statement. Okay. And there are, as you say, parts of the country, and I remember going to a primary school on the south side of the city, south inner city of Dublin. I remember saying, this was about 2 years ago, I remember saying, and how many people here have an up-to-date service statement? And nobody put up their hands in the room, of about 50 parents in the room. Not one of them had ever received a service statement. And I was thinking to myself, no, this is completely wrong. I mean, everyone has a service statement. We might complain about it, but not one had ever received a service statement. So the Disability Act makes it clear that after a completed assessment of need is done, your liaison officer who takes the assessment of need and creates your service statement must do so within 1 month of the receipt. So my argument always is, from a legal perspective, the non-provision of your service statement means you don't have a completed assessment of need, because it's the last step in the process. The last step in the process is to receive the service statement. Now, there are, under the regulations, very, very key ingredients that go into that service statement, and it is unlawful if you don't have those essential ingredients. So in the service statement has to tell, it's a 1-page document, sometimes 2, but it has to tell us some fundamental things. 1, what services are going to be provided. 2, who is going to provide those services to you. 3, what are the commencement dates for those services? And when is it going to be reviewed? And this has all been clarified in the High Court. That service statement has to be updated on an annual basis. And the reason it has to be updated on an annual basis is because those service statements, or the resources that would be attached to that service statement, has to be sent to the Department of Health for expenditure reasons. So that's the reason that you have an updated service statement. And so when you don't get a service statement, well then, as far as an initial service statement, as far as I'm concerned, that is not a completed assessment of need. But say, for example, you said, that, well, I got my service statement, but it didn't tell me when I was going to get X, Y, or Z. I mean, that's another breach of the law, because if it doesn't specify what's going to be provided, when is it going to be provided, and who's going to do it, well then, again, a complaint can be made under Section 4D of the Disability Act about the contents of your service statement. So if you're unhappy with the contents of the service statement, including the timelines. I mean, the other day I got a service statement. I mean, this will shock you, maybe it won't. But I got a service statement the other day where we've just received the service statement and the services are going to commence in June, right? And I thought to myself, they've got this wrong. Surely it's not going to commence in June. And there it is. Yes, it will commence in June, because virtually every service statement I'm getting says something along the lines of, we will have an intake meeting to determine your child's needs in, January 2028. And therefore you're bringing a complaint about the contents of your service statement, because first of all, January 2028 does not align with what was contained in your assessment of need, because quite often your assessment of need emphasizes the need for things to be done expeditiously or urgently. And even if it didn't, the idea that January 2028 is completely alien. The second thing to say is that we've just had an assessment of need that have told us what we need. So the idea that you have to have a meeting to determine what your needs are, when in fact we've just had a 30-page report that tells us exactly what you need, again, is something that goes to the heart of the contents of your service statement. And we are having great progress and joy in having those service statements amended and updated, and the complaints officers and the disability appeals officer in particular setting aside the contents of service statements and demanding new ones. And the other thing that I often find, and again, it demonstrates, I guess, one, how you can see progress in making the complaint, but also the complete unnecessary nature of having to go through this route. But there is also provision within the Disability Act that, say, for example, that lady I was telling you about whose services are due to commence in June. I mean, if they don't commence in June, then you can bring a complaint under the Disability Act where you're asking the complaints officer to make a finding that the services which were specified in the service statement were not provided within the time frame that's contained. So that's Section 14(1)(e) of the Disability Act. And I often find that when those complaints go in, and then the complaints officer has to go to the service providers and to the liaison officers, there is a dusting down of the file, and suddenly, in order to try and get yourself over the hoop of the fact that you are in breach of the commitments provided in that service statement, lo and behold, invitations are certainly issue like an 8-year-old's birthday party. Now, that's not to say that challenges don't exist. They certainly do. And it is an example, sadly, of a system where instead of the best brains in the business working out how to enhance children's rights in those areas, the best brains in the business are often now being used to try and work out, well, how do we kind of give the facade of a service? You know, the great old introductory meeting for a service, the great old IFSP, which is not a substitute for service provision, is complementary to service provision, where, you know, parents are invited to set out goals and aims and objectives, when in fact the goals, aims and objectives, in my view, are already set out by the practitioners in the assessment of need process. You know, a service, in my view, where a child is never seen and then discharged without ever having been seen is not a service. A handout and a YouTube video and an autism awareness talk, for me, you know, is not a service that should be relied on exclusively. All important things, but they're not, you know, it doesn't, from my perspective, meet what is contained within the gold standard reports that are being provided under the assessment of need process. So there are still significant challenges to go through. And always new ones that emerge, Amanda. I mean, as I said earlier in our discussion, you know, every day for me is a school day, because I get people to come and they say the child has been discharged from speech and language, and I say, well, did you get the block of 6? Or, oh no, they didn't see them at all, they were just discharged. You're trying to work out then, how did they discharge you without ever having provided you with a service? And then when you start asking those questions, then suddenly we're reviewing it, and then you get in for a block. It's let's put it this way, it's a marathon rather than a sprint when it comes to children's services in Ireland.
I'm just thinking again back to that conversation with the parent. So this particular parent was saying to me that she delayed applying for the domiciliary because she thought she couldn't apply till she had the service statement. Now, she was more than myself, but in a different circumstance. She was waiting a number of years before she applied for the domiciliary, because she thought she had to have all of the paperwork together. So is that a rational reason then to say as to why you delayed? Or would that be a reason that, now from your experience, and you may not know, but for that parent, or I suppose for any parent listening, because I'm sure, as you just said, you were in a school in the inner city of Dublin where nobody had a service statement. Perhaps one or two of those families, or anyone listening, could be similar. If you delayed applying for the domiciliary because you thought, well, I can't apply without all of the paperwork, is that a valid reason, or would that be a reason or not to, I suppose, give, not even as your reason, but to apply for the backdating or whatever that would be? It's been a while now since I've ever had to apply, but would say, if it was in today's world, is that a valid reason or not?
It's not, and I'll tell you why. The difficulty with domiciliary care allowance is, once you achieve a successful application for domiciliary care allowance, the maximum period it can be backdated to under law is 6 months. Okay, so if you delay in making an application for domiciliary care allowance, the maximum period you can bring back is 6 months. Okay, and we know, you know the examples, I know the examples only too well, where assessments of need, which should be done within 6 months, can sometimes trundle into 18 months, 2 years, 2.5 years, 3 years. That shouldn't happen if we follow the legal route, by the way, but I'm just saying, for some families, they aren't aware that there is an alternative to having to wait 3 years when it should be done in 6 months. Okay, but I would always say to a family, don't delay in making your application for domiciliary care allowance, because number one, I've dealt with many families who've achieved the domiciliary care allowance without having had the completed assessment of need. But secondly, and perhaps more significantly, if you've applied for an assessment of need, but the information hasn't been forthcoming, and you have applied for DCA and you don't get it first time round, then your assessment of need finally comes through. You can actually go back to your original decision maker and submit your fresh information and look for a review of your DCA decision based on information which was relevant at the time of your application, but which wasn't available to you at the time of your application. And that decision can actually be overturned on the basis of that new information. And so when you get a successful revision of your DCA, that will be backdated to the date of your application. So that is a really good way of, you know, making sure that you're in both systems, and when one catches up with the other, if you have been unsuccessful with your DCA, you know, we can bring applications for reviews either to the decision maker or indeed to an appeals officer based on this new and additional information which clearly demonstrates that the child's care needs were substantially greater than other children as per the criteria for domiciliary care allowance, and where, that information was relevant at the date of the decision being disallowed in the first place. So absolutely go ahead with both at the same time is my honest opinion.